Welcome to the Deep Dive, where we take your sources, your questions, and really dig in to find the most important insights you need. Today, we're looking at a situation that's, well, frankly, a nightmare for anyone renting. Dealing with constant harassment from a neighbor and also feeling like your landlord maybe wasn't straight with you about the problem from the start. We have a legal report from a listener outlining this exact issue.
It's just an incredibly stressful position to be in. Feeling unsafe in your own home because things like, well, exposure, constant staring, verbal attacks, even being blocked in hallways. And our listener mentions these specific things happening with a neighbor who they believe might be dealing with a mental illness.
And the real kicker here, according to the sources, is that when our listener raised this with the landlord, the response was apparently dismissive. Like they denied knowing about it beforehand, even though there are hints they might have.
Exactly. So the big questions are, can you legally break the lease over this? Can you get your security deposit back? And maybe most importantly, how do you even prove this stuff, especially given the sensitivity around the neighbor situation?
Yeah, that's what makes this so interesting. And the sources really bring this out. It's not just, tenant versus landlord 101. It bumps right up against the rights of someone else, the neighbor, and these really tricky legal points about potential discrimination.
Mm-hmm.
So we need to understand your rights as a tenant, but also be super careful about navigating that sensitive piece, which the sources really hammer.
Absolutely. So this deep dive will pull apart the legal report you sent us. We'll look at the arguments, the practical steps it suggests, how to assert your rights effectively legally, especially around getting evidence and communicating properly. And critically, how to do all that while being really mindful of those broader legal protections for individuals. Let's jump into these sources.
Okay, let's unpack this whole thing. Based on the sources, let's get really specific about what our listener is dealing with. What kind of behaviors are we actually talking about?
Yeah.
Because the report lists some pretty disturbing stuff.
Yeah, these aren't just like loud music complaints. The sources describe the neighbor allegedly exposing their upper body or sitting barely closed right in the doorway, just staring.
Wow.
Yeah. And constant verbal abuse, shouting profanities, accusing the tenant of spying or doing illegal things based on totally normal stuff like cooking smells, and even physically blocking their way in common areas.
So it's not just irritating, it's genuinely making the place feel unsafe, unsettling. The report mentions a big negative impact, especially since there are children involved.
Definitely. It's described as ongoing behavior that really undermines the basic safety and peace you expect in your own home.
And the landlord's supposed reaction is central here, according to the sources. The listener apparently asked about neighbors before signing, was told things were quiet, then, okay, that wasn't recorded. But after the problem started, the landlord allegedly just brushed it off, like, really? First I'm hearing of it, even when other neighbors apparently knew about the issues.
Exactly. That alleged prior knowledge and then the denial or inaction. That's the crux of the matter, according to the report. It shifts it from just being a neighbor problem to being potentially about the landlord not being upfront about the property's reality. And that sets up the key legal questions you're asking. Can you break the lease early? Can you get the deposit back? And how do you prove the landlord knew?
Right. Okay, let's get into the legal angles the report brings up. The first big one sounds really interesting, this idea that the living environment itself could be seen as defective because of all this. That's not the usual leaky roof definition, is it?
No, it's not. And this is where the sources make a pretty sophisticated argument. Usually a defect in the legal term means physical problems, yeah, like a leaky roof or bad plumbing. But the report argues that severe, persistent neighbor harassment, especially if the landlord knew about it and didn't tell you before you signed, can make the whole living situation unsafe or unhealthy, to the point where it legally counts as a defect.
So the defect isn't the wall, it's the fundamental ability to live there peacefully that the landlord failed to deliver.
That's the core idea, and the sources point specifically to Civil Code Article 424. Now, this article lets a tenant end a lease if a defect puts their safety or health at risk. And crucially, it applies even if you technically knew about the defect itself or waived some rights when signing. The argument here is that the undisclosed risk of this severe known harassment pattern is the key defect that makes the place unsafe or unhealthy. It fits the spirit of Article 424.
Okay, that makes sense. So the landlord, by allegedly hiding a known serious problem, gave you a property where basic safety and peace were already compromised from day one.
Precisely. And the sources also connect this to the landlord's duty to inform DIS. This comes from the principle of good faith in contracts. I mean, a known severe neighbor issue. That's definitely something important a tenant would want to know before committing to rent. The argument is if the landlord hid this or just didn't mention it, they violated that duty, and you signed the lease based on a false picture of what living there would be like.
Hmm.
The report does mention that the standard lease contract's current condition confirmation checklist doesn't usually list neighbor issues. But importantly, it also points out the contract's things landlords can't put in to escape liability prevent them from dodging responsibility if they intentionally hit a defect. So they can't just use the checklist as an excuse if they knew and stayed quiet.
And there's another angle too, right? The right to peaceful habitation, Sheena. The sources say that's a protected personal right.
Yes, absolutely. And severe harassment obviously violates that right completely.
So normally you'd go after the neighbor for that.
You could, yes. But the argument against the landlord, based on the sources, is subtly different. If the landlord knew this property couldn't offer basic, peaceful living because of this existing neighbor situation and didn't tell you, then what they delivered was fundamentally flawed from the start. A defective living experience, essentially. The Residential Tenancy Market Development and Management Act, Synchrodone, also gets mentioned. Articles 8 and 11 reinforce the landlord's duty for habitable property and tenant rights to terminate for safety defects. However, the sources do acknowledge it's kind of debatable whether neighbor behavior perfectly fits the definition of defect under Article 11. So the strongest legal strategy outlined seems to rely more heavily on Civil Code 424 and that crucial failure to disclose a known serious risk.
Okay, so that lays out the potential case against the landlord. But now we hit that really sensitive point you flagged earlier. The sources say the neighbor is allegedly dealing with a mental illness. How does that play into this legally, and what are the big warnings for the tenant here?
Right. This is absolutely critical, and the sources are very, very clear on this. When you're making your case, when you're gathering evidence, when you're communicating with the landlord or anyone else, you must focus only on the neighbor's specific, concrete, objective behaviors. Describe the staring, the yelling, the blocking, the exposure, what you actually see and hear. You have to absolutely avoid making claims, arguments, or even implications that target the neighbor because of their alleged mental health status.
Wow, okay. Why is that so strict? I mean, if the landlord knew about the condition and knew it led to this behavior, wouldn't that be relevant?
It feels relevant, but legally it's dangerous territory. It's because of strong anti-discrimination laws in Taiwan. You've got the Rights of Persons with Disabilities Act and especially the Mental Health Act, for instance. These laws specifically protect people with mental health conditions from discrimination. Article 22 of the Mental Health Act, for instance, explicitly says you have to respect the personality and legal rights of patients, protect them, and not discriminate against them.
So if your argument sounds like you're saying this person is a problem because they have a mental illness.
Exactly. If your legal case against the landlord gets framed, or even just perceived as being based on the neighbor's mental health status itself, it could seriously undermine everything. It could be viewed as discriminatory. It distracts from your core legal point, which is about the landlord's failure to disclose a known, severe behavioral issue that makes the property uninhabitable, regardless of the underlying reason for that behavior. It could weaken your case, or worse, even open you up to legal trouble for discrimination.
Okay, got it. So the laser focus has to be on the harmful behavior and the resulting unsafe environment. The reason for the behavior isn't the point of your claim against the landlord.
Precisely. The neighbor's alleged condition is only indirectly relevant in one specific way. If the landlord knew about it, and if that condition was known to be linked to this kind of severe behavior pattern, then the landlord's knowledge of that connection strengthens the argument that they were aware of a serious foreseeable risk impacting the living environment, and they failed to disclose that risk. It's about the landlord's knowledge of the risk, not about judging or diagnosing the neighbor. This distinction is absolutely vital, both legally and ethically.
That clarifies it perfectly. So if the whole case rests on proving the landlord's alleged prior knowledge and documenting the impact of the behavior, then evidence becomes paramount. What kind of proof does the source material say you need to be gathering? Like, really carefully.
Yeah, this is where you need to become almost like a detective, very systematic and objective. The report spells out several key types. First, a detailed event log. This isn't just scribbling notes. It means date, time, exactly what happened, what was said, what was done, how long it lasted, where it happened, hallway, doorway, etc., who else saw it, and importantly, the impact on you or your family.
So turning feelings into facts.
Exactly. It builds a picture of persistence and severity over time, and the report stresses keep it objective, stick to the facts, and write it down right after it happens while it's fresh.
Okay, the log makes sense. What else?
Second, audio and visual evidence. Photos can be useful maybe of physical barriers they put up, or if the exposure happens in public view, you have to be careful about your safety when taking photos, of course. And audio recordings of the verbal abuse or maybe really disruptive noise.
Ah, recording. That always feels legally iffy. What do the sources say about whether you can legally record a neighbor like that?
It is tricky, you're right to flag that. The sources bring up the Penal Code Article 315.1, which deals with obstruction of privacy. However, they clarify that recording for self-protection and evidence gathering is generally considered okay when you are directly involved in the interaction. So if the neighbor is yelling at you or doing something to you or directly impacting you in a common area, recording that specific interaction is likely permissible.
But not like spying on them inside their apartment.
Absolutely not. You need to be super careful not to be invasive or record purely private conversations or activities within their own space. The focus has to be on capturing the harassing behavior itself as it impacts you, especially in shared spaces or when directed towards you. Privacy boundaries are key.
Got it. What other evidence?
Witness statements are great if other neighbors or visitors have seen or heard things. Also, police reports. Even if the police don't make an arrest for something like yelling, calling them for serious incidents like public exposure or threats creates an official record that an event occurred. And, crucially, keep all communication records with the landlord and the building management. Emails, text messages, notes from calls, and especially any formal letters you send.
You mentioned formal letters. The sources really emphasize the certified letter because why is that specific type of letter so important?
It's a really critical legal step outlined in the report. A certified letter isn't just mail. The post office verifies the content of the letter and the date it was delivered. So it creates undeniable proof that you officially notified the landlord on a specific date about specific things. The report advises that this letter should clearly lay out the facts of the harassment, how it's impacting you, the claim that the landlord failed to inform you beforehand, the legal reason you're terminating the lease, like citing Civil Code 424 because of the undisclosed safety issue, your decision to terminate, the date you plan to move out, and a clear demand for your full deposit back. It often suggests a time for a final handover inspection.
So it puts everything formally on record and shows you mean business.
Exactly. It signals you're taking this seriously and potentially pursuing legal remedies.
Okay, this is a lot to handle. Documenting everything, understanding the legal nuances, writing formal letters. Sounds exhausting to do alone. What kind of help does the report say is out there?
It definitely is overwhelming. But the good news, according to the sources, is that there are quite a few support systems in Taiwan specifically for rental disputes. For instance, you could approach the building management committee if your building has one. They might have rules the neighbor is breaking. Even if they can't force a resolution between owner-tenants, their records or involvement can sometimes serve as evidence. Their power might be limited, though.
And the police, as we said, for immediate safety, but not the lease issue itself.
Right. Call them for safety threats or potential crimes, get that report filed, but they won't mediate your lease termination. Where the sources really point you is towards alternative dispute resolution ADR before you even think about court. There are local government mediation committees, HECHUCHAS. Consumer protection agencies can sometimes help too, as tenancy is seen as a consumer relationship now. But the really key one highlighted in the report is the Real Estate Dispute Conciliation Committee, SIDGES. You access this through your local government's land administration department. And here's the big benefit mentioned. Under Article 16 of the RTM-DMA, conciliation for residential lease disputes is free.
Free conciliation. That sounds like a huge advantage, trying to work it out without massive legal fees.
It really is. And if you manage to reach an agreement through conciliation and it gets court approval, it basically has the same legal power as a court judgment. It's usually way faster and cheaper than a lawsuit. And don't forget legal aid. The report lists some excellent options for free or low-cost legal help. The Legal Aid Foundation, they offer free consultations, help drafting legal documents, and might even provide a lawyer to represent you in court if you meet their eligibility criteria for rental disputes. They even have a dedicated hotline.
Okay.
Plus, many local city or county governments have free legal consultation services, often staffed by volunteer lawyers at set times. And then there are specialized NGOs like the Mama Foundation. They really focus on housing and tenant issues and offer free legal advice and sometimes help coordinate dispute resolution.
Wow. Okay. So it sounds like there are definitely places to turn for professional guidance through this legal maze. That's good to know.
It really is. So, putting it all together, the report suggests a pretty clear action plan. Step one, and maybe the simplest, double check your actual lease contract. Read every clause. Is there any chance it already has a provision allowing either party, you or the landlord, to terminate early, maybe with 1 month's notice or by paying a penalty like 1 month's rent? If that escape hatch exists in your contract, just following that procedure might be the least painful way out, even if it costs a small fee.
Okay, but assuming that easy out isn't in the contract, then you move to the full strategy we've been discussing.
Exactly. If the contract doesn't offer a simple exit, then the plan is keep gathering that detailed, objective evidence. Log everything. Get recordings if safe and appropriate. Talk to witnesses. Then get professional legal advice right away from one of those resources we mentioned. Don't try to wing it alone. Get their input on your specific facts. With their help, draft and send that formal certified letter to the landlord. Make sure it's factual, cites the right legal basis, like Civil Code 424, clearly states your intention to terminate, demands the deposit, and critically, uses that careful language we discussed, focusing on the behavior and the landlord's alleged failure to disclose, not the neighbor's health.
And then wait for the landlord's response.
Right. See what they say. If they agree to terminate and refund the deposit, great. Get it all confirmed clearly in writing. If they refuse or ignore you, the next step recommended by the sources is to prioritize using those free mediation or conciliation services. Really try that route first. If, unfortunately, mediation or conciliation doesn't work, then the final option is pursuing a civil lawsuit. You'd ask the court to formally confirm the lease termination is valid and order the landlord to return your security deposit.
Does the report mention anything else, like suing for stress or moving costs?
It does briefly touch on potentially claiming other damages, like compensation for mental distress if you have solid medical documentation, or maybe extra costs you incurred because you had to move unexpectedly. But it also cautions that adding these claims makes the lawsuit more complex and harder to prove. The main, most achievable focus, according to the report's analysis, should probably remain on getting the lease legally terminated and securing that deposit refund.
Makes sense. And finally, amidst all this legal strategy and evidence gathering, what's the absolute #1 priority the report keeps coming back to?
Your personal safety and well-being, period. The report stresses this repeatedly. If the harassment gets worse, if you feel physically threatened or genuinely unsafe at any point, call the police immediately. Don't hesitate. And if living there just becomes unbearable while you're going through this legal process, the report suggests you might need to consider finding a temporary place to stay, even with the added cost and hassle, just to ensure your safety and sanity. And lean on your support network, friends, family. Maybe even consider talking to a counselor. This kind of situation takes a huge emotional toll. Your health and safety have to come first, above everything else.
This has been a really insightful deep dive. It shows that even in the incredibly tough situation, based on the sources you provided, there are potential legal paths forward. Primarily arguing that the landlord's alleged failure to disclose a known severe issue created an unsafe living environment, possibly amounting to a legal defect.
Yeah, and the key actions involve that careful, systematic evidence collection, using formal communication like the certified letter, and really taking advantage of the free legal aid and dispute resolution options available in Taiwan to try and end the lease and get that deposit back.
And remembering that absolutely critical point, frame your case around the neighbor's objective behaviors and their impact, and the landlord's alleged knowledge and non-disclosure. Steer completely clear of making it about the neighbor's supposed health status to avoid running afoul of discrimination laws and potentially hurting your own case.
It's definitely a complex balancing act, isn't it? Tenant rights, landlord duties, neighbor conflicts, and the overlay of protecting the rights of third parties. But the sources you shared give a solid roadmap for how to approach this within the current legal framework.
So what does this all leave us thinking about? Maybe it highlights the fundamental tension in shared living spaces. How do we balance everyone's right to feel safe and peaceful at home with the need to uphold the dignity and legal rights of every individual, even when behavior causes significant conflict? And perhaps it makes us question whether our current legal definitions like defect fully capture the impact that persistent neighbor harassment can have on the very habitability a landlord is supposed to provide. It's certainly food for thought.